Already live from Houston, Texas, every Tuesday at 5 p.m. Central Time. Today, along with me, is my business partner, Reddy Neumann. Emily, what do we have discussed today?
All right, so we have an update on the EGLE Act of 2022. It was introduced in the Senate, which is new for this year. So we'll talk about that and what the prospects are, whether we need to take any action on that right now. Talking about the 485 processing for employment-based, and we have all these applications pending. Is CIS really following the first in, first out, which they claim they are? We also are getting a lot of questions about what happens when your priority date has been current for 1 year. Can you still extend your H-1B? Do you lose your priority date? I get that question all of the time if you haven't been able to file your 485 yet. And lastly, we wanted to give you some do's and don'ts of what to do when you're in H-1B status so you can avoid violating your status or running into any issues during your green card process or stamping.
Emily, I've been seeing this EGLE Act, the version of it to remove the per country limit since the time I've been practicing, much before you started even law school. What are the prospects right now? Now we have the Senate in the control of the Democrats. We have the House in the control of the Democrats. And of course, the president is also Democrat. Things seems to be in favor. It's been a long time. This circumstances has been there. It was only 4 years, first 2 years of the Clinton, which I don't remember. I was not practicing. Then after Obama, that's only 2 years I was there. And now we have that atmosphere where all the things, and we have the House member, Joe Lovegreen, who's been an active member. Mm-hmm. So what are the prospects that this can go through though and become a law? Yeah, so we have. And what are the steps also needed? Mm-hmm.
We definitely have, I guess, the right people in power to make this happen. Before we can get it anywhere, first it's going to have to be actually introduced and it'll be assigned a bill number. I don't believe that happened yet. Then it has to go to the various subcommittees. It'll go to the Judiciary Committee, which handles immigration, in the Senate, where those senators will first pick it apart. They have the opportunity to add amendments, make changes, discuss it, debate it, and then it has to be passed out of that committee. If that committee approves it and passes it out of the committee, then we have to get it brought up to the floor of the Senate and try to go through debate and amendment there. Last time around, this was successful in December 2020 in the Senate. It went through several rounds of this unanimous consent where they tried to just make sure everyone agreed with it, and one senator had the ability to say, no, I don't agree with it, and then the whole process stopped and they did negotiations and then made everybody happy and tried it again. Eventually, it did pass the Senate in December 2020, but because it was a different version than what the House passed, there wasn't enough time left in the year for them to come together and reconcile the differences to be able to pass it and get it on the president's desk. So we are ahead of the game now in the fact that this is happening in July, not in December. The other thing that's interesting, I've noticed in the press release this year compared to what was going on December 2020, they're tying this to the idea that companies are having trouble filling jobs. We know, generally unemployment is low, and companies really, since things have gone back up after COVID, companies across the country are saying that we can't find the workers. We don't have enough people to fill all of our jobs. And so they're saying that if we were to pass this bill and people could get their green cards or at least get their employment authorization by being able to file the 485 earlier than normal, we may be able to help the economy by filling these jobs. So COVID may have helped us a little bit in that front in providing a new argument in favor of this change. We still have a long road to go. It's got to get done by the end of the year. Really probably before November, since it is an election year. And if we don't get it done this year, we may have to wait 4 years because—
Why 4 years?
Yeah, so with the election coming in November, it's likely that the Senate will go back to Republican control, and then we lose our majority in both of the houses and with the president, and then things get a little more difficult to negotiate. So ultimately we'd have to wait until we have Democratic control again, assuming that happens in 4 years.
One other thing, what Emily has said, I have to tell you that historically, in the elections after the president gets elected after 2 years, though, especially the House changes its color, and that happened every time it's been there. I mean, when Bill Clinton got elected, the same thing happened. When Bush got elected, the same thing happened. When Obama got elected, the same thing happened. When Trump got elected, the same thing happened. we're expecting the trend to continue, that since this November the election is going to be. However, I'm expecting things to smooth through a little bit faster, even though when I looked into the previous act, where they were trying to remove the per country limit, they may have started a little bit before than this. I'm expecting it to pass through because it's already passed in the previous Senate and the House. I am still expecting this to be a lame duck session. That is, that things will be negotiated after the November elections, before the Congress changes. And elections happen here in November, and the Congress, which in Parliament is called as Congress in the United States, will be changing in January though. I mean, there is a period of December, November beginning is the election happens, as November and December. So that's when the senators and the House members are more daring to do the things, because hey, they don't have to face the election for the next 2 years. So that's when they're daring, and some of the people are outgoing. One thing I want to point out about this Eagle Act that's presented in the Senate is it is bipartisan. The people who are supporting the senator from Colorado and the senator from Colorado and Republican senator is also the co-sponsor in this one. So definitely this is a good sign. Senator from North Dakota, the Republican junior senator from North Dakota and junior senator from Colorado, both of them belonging to different party, are the co-sponsors of this bill. So that's definitely a good sign. And we have seen that in the House though, which is the lower house of the Congress, or they call it as lower house of the Parliament, things are, I mean, we are very sure that it's going to pass through the lower house though. But when it comes to the Senate, that's where we're going to face the hurdles. Now may not be the right time for us to start doing the letter writing campaign, but we want you to be ready that when we request you, you should be able to write the letters and contact the senators whom we tell you to contact. Remember the activity what you guys have done to get the 280,000 green cards. Definitely it is working, guys. If anybody tells you all these letters, all what you do doesn't work, look at it. 280,000 green cards are about to be passed now, about to be given in this year. Now don't stop writing the letters, please. Keep continuing the writing the letters though, so that the 280,000 green cards will be given. But it seems that they are most likely to be given, but keep up the pressure. But we will update you on when to write the letters. When we think so is a peak time to write the letters, we will update you on that. Emily, why can't the 485 be approved first come and first out? The cases that we filed in October of 2020 are not getting approved. The cases we filed in April of 2022 getting approved. Any sense in it? Is there any way we can fight on this?
I think there's no sense in it. I mean, there's some reasons behind it. I think most of them are just USCIS is just scrambling as usual. But some of it, they do have a difficult job if you think about it. In October 2020, yes, they got all of these filings, but they had these downgrades to deal with, which they weren't prepared for. So some people's 485s couldn't be adjudicated because the EB3 I-140 was still pending and couldn't be approved in time. Then those dates retrogressed, and then once those applications kind of get shelved or put on hold because either the I-140 is not approved or the date is not current because they're an EB3 or whatever the case is, they kind of focus their priority on the newly incoming applications, and it's very difficult for them to go back and pull the old ones. So anytime there is a big backlog and the processing times become horrible and they put all their efforts to try to fix the processing time, we always notice they work at it on both ends. So they start with the most recent filings so those don't get backlogged, and they hurry up and approve those, and then they take longer to move on the older cases. So it's not unusual. Unfortunately, I don't think there's anything we can really do about it. They're just scrambling to try to get everything and maybe picking the easiest cases that are more readily approvable and available in the right location. They will eventually get through them, but I don't know if there's anything that can be done besides, if you are stuck at Texas or Nebraska, make sure it's not because your I-140 downgrade is still pending. Get that upgraded to premium. Refile in EB2 is still an option. if interfiling is not working or if it's keeping your case stuck in Texas or Nebraska.
I mean, it's if my case is in October, if my case is stuck there in October, definitely. I'm really annoyed right now, though. And then the people who filed in April of 2022 are getting approved, though. But in general, at this point of time, I don't want to touch the USCIS. I don't want to give any draft letters to our members so that they can completely go ahead, because it may actually crumble the thing, and they may not use the 280,000 green cards. I'm a bit worried about it. Let them cut all the low-hanging fruits, and of course we'll handle them later on, though. But as such, especially if the cases get stuck in Nebraska, they're not moving that much. Yeah, it's definitely, as Emily has pointed out, get the I-140 approval. If you have not filed the medical, it may be appropriate time for you to do the medical interfiling that we have suggested. It works most of the time, not all the times, but you can try that one if you want to. But as such, there is nothing else you can do. We'll have to just see. In July also of 2022, I mean, they are approving a good number of cases. We do expect the 280,000 green cards to be done. And maybe because they have used up all the numbers, maybe if all the members before you get the green card, I mean, you're the only person left out there, it'll be easy to handle it in October of 2022, because most of the people before you, even after you have got the green card, so you will definitely be in a good line to get the green card, but as such, nothing can be done right now. Emily, now, this is a very common question that I get. My priority date has been, final action date has been current for more than 1 year. Is my life ended in the United States? Can I mean, I have an I-140 approval with company A, and the priority date is 2012, EB2, let's say September of 2012, and it's going to be current, final action is going to be current for the past 1 year. Can I still extend the H-1B?
Yeah, so this is the situation where you haven't been able to file the 485 because you're no longer with that company, and your new company, PERM, is still in process. We know prevailing wages have been taking forever. PERM has been taking forever. So you don't have that I-140 filing yet to be able to file your adjustment of status. And if your H-1B is coming to an end, when you're filing an H-1B extension and your final action date is current, you're only eligible for a 1-year extension at the most, because they expect that you'll be filing the 485. But if your final action date has been already current for a year and you still have not filed your 485, the ability to extend that H-1B is technically discretionary with USCIS, so they get to decide whether you qualify for it or not. But we've never, at least in this round of craziness with USCIS, we've not seen them denying H-1 extensions that are requesting that 1 year because the 485 wasn't filed yet. They understand that not everyone was in a situation in October 2020 to be able to file the 485, and then the PERMs are taking longer. So as long as you're making progress towards getting that new labor certification and I-140 in place, you should be able to get at least the 1-year extension to then file the 485.
Right, and then there are many excuses why you didn't file the 485. One, you may not be working for that company. There are also another excuses even if you are working for the company. For example, what if your position is different than that of what they filed the labor certification on I-140? As of now, Emily, I have not seen a single H-1B extension denied because of that reason. And not only now, as at ever, because priority date is not only current for the Indian nationals, but for non-Indian nationals. So it has been current forever. We have not seen any denials of the H-1B extension. There may be one or two occasional RFPs where we explain the things, though, but as such, they did not. So in particular, though, even though it's discretionary, though, they can't just approve for 99 people and deny for me. Yeah. And they have to give a reason why they are denying it for me. So which I did not find it yet, though. What about this other reason, Emily, that I'm going to lose the priority date? Is that true?
No. So that's another thing, is people think, oh, if I'm not able to file my 485 within 1 year of the date becoming current, I lose the whole process, including my priority date, and I have to start everything over. And that is not the case. That priority date is yours and it's locked in. With consular processing, if you are going through this green card process while you're outside the US, yes, there is a rule that says if you fail to act to when the visa is available within 1 year, the process ends and they can terminate the whole process and send the I-140 petition back for revocation. When you're filing the adjustment of status, that is not the case. You still don't lose the priority date ever. So you don't have to worry about that.
What if I move from company A to company B and it's been final action date has been current for more than 1 year? Can company B still file a I-140, labor and I-140 and retain the priority date of the previous company MD?
Yes, no issues at all.
Okay, now let's go to the, unless you have anything else.
One other thing I wanted to mention on this ability to extend the H-1, for those of you that did do the downgrade, but maybe you changed employers after that and have not been able to interfile to upgrade back to EB2, so you're stuck in EB3, you can use the EB3 I-140 to extend your H-1 for 3 years if that final action date is current, even if you have an EB2 I-140 whose final action date is current. So don't forget that you get to choose which I-140 you're going to use to extend your H-1. So if you have two and one of them would give you a 3-year extension and one only gives you a 1-year extension, go ahead and submit the one that gives you the 3-year extension because the date's not current.
Let's go to the do's and don'ts on H-1B, Emily, that I want to describe people to. Especially a lot of people, when they move to a different location, right now the law is that you have to file an amendment. Don't wait 2 weeks or 1 week after you move to the different location. Try to file an amendment before you move. That's one mistake that I see. Another thing is that if your H-1B is expiring, let's say in December of 2022, file the extension in July. Don't wait all the way to November or December and file the extension. Try to file it. Try to get the result of the H-1B extension before the I-94 expires. Don't wait, let's say your December 2022, the I-94 is expiring. You wait for the H-1B adjudication, you go to January or February, you get a H-1B extended denial, then you may have to leave the country and then you'll have to apply for the H-1B and come back. Please try not to do that thing. And if necessary to get it adjudicated early, please do the premium processing, it's worth it. POM labor certification or green card application, try to file it as early as possible. Don't go to the 4th year, 5th year, 6th year. Try to file the POM application early itself, not at a later date. Please remember that you can always leave the company after 180 days the H-1B is approved. Then you can carry that I-140 for a successive H-1B extensions. You don't have to get the I-140 labor filed by company B, company C. So that's one thing that I want you to be very careful about. There's also called, you can do multiple jobs if you want to. There are ways to do it where second company can file as a concurrent H-1B. Please check with a lawyer or the company lawyer. They know how to do it. The second company need to know that you're working for the first company and second company. Don't work for 2 companies at the same time unless the H-1B is being filed as a concurrently filed H-1B. You can trade the stocks on H-1B, absolutely nothing wrong. You can invest in some businesses, but you cannot work for the businesses. For example, you can invest in a restaurant, but you cannot go to the restaurant and manage the restaurant. I want to be very careful when you're investing in restaurant, though. Consult a lawyer before you go. But if you're going for stocks, you're fine. I mean, I'm not telling you should invest in stocks, what stocks you should. I'm not a financial advisor, but I'm just telling you that you have the legal authority to invest in stocks and trade in stocks. Anything in them?
Also want to add, stay away from drinking and driving. A DWI or DUI is much more difficult to deal with in terms of visa stamping, green card process extensions and all of that. And stay away from marijuana. Don't even go in a store that has it. Stay completely away from it, even though the place where you're at, it might be legal according to state laws. For federal law, it's not legal, and immigration always falls under federal law, so it's not legal for anyone who is here on a work visa or non-immigrant visa or working towards the green card.
Can I invest in 401k plan, Emily?
Yes, absolutely, no issues at all.
One other thing why Emily is telling not even enter into the store of marijuana is marijuana, which is also called in ganja in Hindi and also ganjai in Telugu, are illegal according to federal law. And even you enter into the store though, they will ask to give the driving license to be scanned, and that goes into the federal record. So that may end up into trouble. It is not legal in the federal law. I'm not going to comment anything about the state law. I don't do the state law subject, but don't even enter into a place that is selling marijuana. I mean, this is very important. A lot of people innocently, they go along with the friends. Look, I'm not trying to buy. I'm not trying to do anything. I'm just entering with them. No, don't even enter into that place which sells marijuana. Anything else, Emily, before we?
I think we can go to questions. And we'll start with Ragini, who says, are the CESPA rules, CSPA, Child Status Protection Act, the same regardless of the underlying visa status, like H1, H4, or L1, L2? And is it the same regardless of the green card category, EB1, 2, or 3? Any difference or exceptions? No, it's exactly the same across the board for everybody. It's based on either an I-140 or the I-130. They will look at the child's age at the time the final action date becomes current, either under whatever employment-based category or under whatever family-based category. Take that age and subtract the amount of time the I-130 or the I-140 petition that you're filing based off of was pending, and if the age is under 21, that child's age is locked in, as long as they seek to obtain the green card by either filing the 485 or submitting the DS-260 for consular processing within 1 year of the final action date becoming current. Does not matter what status you're in or what category you're in within that.
Ranchit Disha has this question. 485J interfile sent to California address on July 7th. That's good. If USCIS does not process the application by September 30th, is there a chance I can get the GC after September 30th if the priority dates remain current? Absolutely, you will. I mean, there is no requirement that you have to get the green card by September 30th. I don't know, for some reason people are thinking that if you don't get by September 30th, you won't get it. That may not be true because we're expecting some spillovers for the next year too. So definitely, just because you don't get it by September 30th, you can still get it afterwards. No problem with it. You interfiling is done before September 30th. You're in a good position though.
Radhika wants to know, she's been staying in India for about 6 months while her 485 is pending. She's the dependent on the application and has the advanced parole. Do I need to do anything to inform USCIS? No, you don't. As long as you make sure you come back before the advanced parole expires, or in the event you're called for fingerprinting or an interview. Other than that, you don't have to proactively tell USCIS that you've left.
Noor has this question. File moved from NBC to non-local field office. Received EAD, Emma confirmed file moved back to NBC and now in the local field office. What can we expect? Can we move, file move to two field offices? There is a chance the file can be moved to two field offices, because sometimes if the officer feels that there may be an interview required, they may have sent it to NBC, and from there they may have send it to the local field office where you are at, because that's where the interview will be conducted. But there is still a chance that you may get a green card without an interview, because the officer at the local office may look and say, hey, this is approvable, I can approve this case. So there's a chance for that too.
Asim says his employer is not filing for the perm and I-140 and wants to know if there's any way for his spouse, the H4 spouse, to become eligible for the EAD. Unfortunately, that is the only option for an H4 EAD. It's only available for certain spouses of H-1B holders, and that is when the H-1B holder has either extended beyond the 6-year limit because they have a perm or I-140 in progress, or they have an approved I-140, which allows them to continue extend the H-1. Beyond that, your spouse may need to look at obtaining separate immigration status, like their own H-1B or an L-1 for themselves, or an O-1 or something like that, in order to be able to work.
I have a valid H-1B, this is for Rahul Jain. He has a valid H-1B stamp until September 25th of 2022. H-1B I-797 along with the I-94 is until 2025. When he comes back from India, coming back before September 22nd of 2022, will he get a I-94 until 2025? Yes, Rahul, you should be getting a I-94 until until 2025. But make sure when you enter into United States, don't just show them the passport stamping and enter. Tell them along with the passport, you will be working for this extension or this. If you change the company, tell them it's a change company. If you have the extension, make sure you mention to them, look, I have an extension. Can you please grant me I-94 until 2025? And as soon as you enter into United States, make sure you go online, you check whether or not your I-94 is updated until 2025. If by any chance it says September 25th, 2022, you then immediately contact an immigration lawyer. Don't wait for 10 days. Don't wait. As soon as you enter it, you check it, because there are ways to correct it. If you check it before September 25th, if you check it after September 25th, you will be in trouble.
Ashok has a medical exam dated from back in May, but he hasn't submitted it to his 485, which is at the NBC, and wants to know if that medical is still valid because it's after 60 days since the doctor signed it, or should he wait for an RFE or interfile? So assuming that you did the medical in May after USCIS already received your 485, then that medical is valid for 2 years. You don't have to worry about submitting it within the 60 days of the civil surgeon's signature. So you can go ahead and interfile that or wait for the RFE. It's good for 2 years. Either option is fine.
SS has filed EB3, refiled EB2, pending with Nebraska. Both are approved. Should he do interfile to get the GC quickly? We don't recommend it. We don't recommend it. That's up to you. It's not illegal. We don't recommend it. One thing that we noticed is that Nebraska is a little bit late in transferring the applications to the USCIS as compared to Texas Service Center.
Pallavi has an EB1C I-140 filed, and the 485 has been pending for more than 6 months, and wants to know if I change my job, does the new employer need to file the I-140 again? So since your 485 has been pending for 6 months, even though it's an EB1C, which is based on an international multinational transferee, you are still eligible for AC-21, which means that once your 485 is pending for 6 months, you can move to any other employer or even a different job within your company, as long as the new job is similar to what you were originally sponsored for, and have the new employer submit a supplement J. They don't have to file an I-140 or another 485. That being said, it makes me a little bit nervous when people do that when their I-140 is not yet approved. So if your EB1C I-140 is still pending, I would prefer that to be approved first and then make the switch. And the reason for that, although AC-21 doesn't require the approved I-140, it does require that that I-140 be approvable when it was filed. And once you leave that company, if they send any kind of RFE on that issue, they may send it to your old employer. The old employer may not be willing to take the time and hassle to respond to that. And so that I-140 is at risk of being denied, or the company could even withdraw it. So for that reason, double check if your EB1C I-140 is approved. If it has been and your 485 has been pending for 6 months, you are safe to change jobs.
Sandeep has this question. Can Reddy Neumann PC help through lawsuit EAD and AP application pending from October of 2020? Yes, that's a very right case. For you, you should contact Stephen Brown in our office. You can have the appointment link. His name is Stephen Brown. Don't make an appointment with me or Emily. The person who is in charge of who does the lawsuit in our office is Stephen Brown.
Manoj says he's on H-1B. If I travel and come back on advanced parole, will I be entered in H-1B status? And then after I come back and do a job change with an H-1B transfer, will that travel on the AP affect the transfer? So first, when you leave and when you're coming back on AP, you will be entered as an advanced parole holder. So no, you will not be entered on H-1B. If you look at your I-94, it will not say H-1B as your status. But once you are back after you've entered on advanced parole, USCIS memo does say that you can extend your H-1B even though you've entered on advanced parole, as long as you've maintained your same job, basically maintained your H-1B status even though you're not in H-1B status. So you can file a transfer in that situation. as if you entered on H-1B, but technically you're entering on AP. The approval of that transfer puts you back in H-1B status.
Pizza party, nice. I like the party. I like pizza. Sounds like adjudication numbers went down. That's what he's saying from YouTube in July. Your thoughts? No, pizza party. I disagree with you. Even though Emily may have not updated the current ones. And the other thing is that normally when the cases get approved in July, though, it takes a little bit time for us to get it because we count only when the approval comes in. And we have noticed a good number of cases that got approved in the first 2 weeks of the July. Now, the rest of the third week and fourth week, we'll get it at a little bit later time. We didn't have time to update it, but I disagree with you, Pizza Party, that the numbers have gone down in July.
Sargit says, as a student, my daughter is on the EAD for a 485 and she has the AP. She aged out of H4. Is it okay for her to continue her studies? We applied for the F1 as a backup plan, but USCIS sent an RFE asking why you applied for an F1 when you have a 485 pending, which is questioning your non-immigrant intent. So I'm assuming her age is locked in. So she's under 21 at the time the final action date became current, so that in that situation she can rely on the adjustment of status and technically doesn't need the F1. If she chooses not to use the F1, she can study while she's in adjustment of status and she can use that EAD to work. No issues at all with that.
Can I apply for H4 EAD with H1B amendment in process for 4 months? Yes, you can. I mean, is it an H1B amendment plus extension or just an amendment? If it's just an amendment, you could actually use your H1B approval that you have. If it's an amendment plus extension, I'm going to use the H1B amendment. Ranchit, I'm residing in California. A lawyer sent EB3 to EB2 interfiling 485J application to California. Okay, sounds good. That's the only address we need to send. Send medicals to Nebraska, which is possible because if your application is interfiling medicals to Nebraska, it's possible because if your application is pending in Nebraska, you can. And send spouses 485 application to Arizona USCIS office. What could the reason? Yes, they are all fine. I mean, I don't have the exact address for California, whether it's Arizona or not, but most probably it looks like it should be Arizona. I may be not right. Yes, all those things seems to be rightfully done. I don't see anything wrong with your lawyer.
Ashwani says, I did the I-131 expedite for myself and my dependents and got the EAD and AP approved last week only for me. Will this cause any issues to my 485 processing timeline? Generally, no. The expedite request was just of the just really of the I-131. So that does not impact the 485 processing time. But when people are doing so many expedite requests and so many customer service requests, USCIS is having to take officers off of adjudicating cases to dealing with these expedites and that sort of thing. So definitely you only want to use that when you meet one of the criteria for the expedite and it's a really urgent issue. So just be careful of doing constant service requests and expedite requests.
Contact with Congress, especially when it's not out of the line. There is a rumor, I can't tell who it is, but they call it as caboose. What does caboose means? When some child misbehaves, though, they put behind the line. So especially if your application is going through normally and it's going through the officer, is about to get adjudicated, it's in line, now you get this expedited request, congressman request, ombudsman request, all those things. They'll pull that thing out, take to a different place to see if its expeditedness is needed or not. Now that gets out of the line. So be careful unless it crosses the law, unless it crosses a processing time though. Don't keep on pounding upon your case. It may not be worth. Take the simple steps of getting an I-140 approval, filing and interfiling the medical. Those are the better steps to do it. But by constantly contacting is not a good advice.
Feb says, I'm on H-1B in the US with my approved I-140, but my family is in India and has the H-4 visa interview in January 2023. Can I file the 485 separately, or should I wait until the family arrives in the US to file the 485? So technically, yes, you can file it by yourself, and then while yours is pending, if they are able to come in on H4 and your priority date continues to be current, they can simply file the 485 at that point and join with your already in progress case. What you have to be worried about is, what if your 485 gets approved before they get here? Then they can't get here on H4 and they can't file the 485 with you. Or what if the priority date retrogresses and then they can't file the 485, so then they'll be coming in on H4 and may have to wait some time until your date becomes current again before they can file. So there are definitely risks in doing that, but technically, yes, it can be done.
Emily, I want your attention a little bit debate about this discussion that I'm going to have it. Raghavendra Nagapalli has this question. File has moved to NBC. Prior to date is April 3rd, 2014. Can I consider now to interfile or already late? So most probably he filed in downgrade application in EB3. Now he wants to consider to be interfiling though. He didn't interfile, but they transferred to NBC. We are noticing this a lot. I would still recommend for him to interfile, Emily, in EB2 if he has not already done. If you have already done though, I would not interfile, but if you did not. Now also, Emily, what if he has moved from company A to company B? Company A has downgraded and filed the 485 application. Can he still do the interfiling if the company B does not have the AB2 I-140 approval?
I think the technical answer is no, you shouldn't be allowed to do it, but in reality, USCIS is allowing it and approving it.
I don't know why we are technically saying that it's not approvable. When I looked into the USCIS website, it says you can use the old employer's I-140 approval. It never said that you cannot use the EB2, you can only use the EB3. Now, when we are filing the 485J supplement though, in the form, it's asking us, does this employee has an I-140 approval, I-140 application? Then you say yes, of course, otherwise this guy, and then we have to give the I-140 approval number, then we have to give an answer to this, is this I-140 approved or not? It never said that. You have to only use the subsequent EB3 I-140 approval. Anyway, when the 485J has been filed by the company B, the I-140 doesn't belong to company B, it always belongs to company A. We are filing EB3. Now, of course, I told otherwise before though. So why can't we use the EB2?
Well, USCIS says in their interfile supplement J, all of that guidance, that there's a FAQ. Why are we requiring you to submit a supplement J in order to do an interfile? And they clearly say, because we need to verify that your company is still offering you the job. Yeah. Or it hasn't gone out of business or something like that.
So in this case, the company B is not got out of business. The offer is still there. All they are using is, instead of EB3, they're using the EB2. Now, this idea did not come to us before that we can use the EB2. It came because the USCIS has approved the cases pointing out to use the EB2 of the company A. And we have offered, our office is offering right now services that you can use our office. If your company A is cooperating, that's better to do it. If your company B wants to do it, we can help you out. If company A and company B still don't want to do it, you can request yourself by writing a letter to the USCIS. Look, I have an EB2 approval from company A, I want to use it. The reason why we are pointing this is USCIS in its RFE is indicating that why can't you use the EB2 of company A? That's another thing. And there are some cases, Emily, where we got the 485 approved. In the case of Raghavendra Nagapalli, where his prior date is EB3 2014, he filed in EB3. He has an EB2 approval with company A. He moved to company B now, and they approved it in EB2, and we challenged it. You went to the USCIS and you found out what? They have an authority to approve it with the previous previous company's I-140 approval in EB2. So yeah, you should interfile. That's one answer to you. Even if you're not working for the company, you should consider to use the EB2 of the previous company to interfile and get the approval, because USCIS under the tremendous pressure of approving it, and they just want to approve it whichever way it's approvable, and they, according to them, you can use the EB2 of the previous company. Emily?
Kellyanne has a very common question. My 485 is approved, yay! But my supplement J is still pending.
Oh.
Is there any issue, any concern? No issue at all. You do not need the supplement J approval. It doesn't do anything for you. Don't worry about it at all. Please don't file another supplement J. Don't ask them to send it. You have your green card. You don't need a supplement J approval. You're fine. Avinash says, I filed my 485 EB3 downgrade in 2020, transferred to NBC in April 2022, and also refiled the EB2 I-485 in April 2022 because the date was current at that time. And the question is, when I check with Emma or speak with USCIS, my case is still at the NBC and not transferred to any field office. Is this any concern? No, I don't think so. NBC is processing the cases as well. Not every single case goes to the field office. They're utilizing the field offices in these interview waiver cases just to provide additional capacity. So they're using officers at the NBC, they're using officers at random field offices that don't belong to you, and then they're using the officers at the field office where they do actually need to do an interview. So they're not required to send it to a field office in order to adjudicate it.
Siesta from YouTube has this question. Does the marijuana advise stepping into the store hold true for the GC holders going for citizenship? Yes, it holds true for GC holders stepping into the store. It may affect citizenship. They may ask the questions. They may deny the citizenship if you have used that marijuana.
Nitin says, my EB3 to EB2 interfile was just transferred to NBC July 18th. Any ETA on getting my GC approved? After the transfer to the NBC where the final action date is current, we're typically seeing on average about 60 days from the time of transfer to the time of approval. It can be faster than that. It can also be longer than that, especially if they end up transferring it to a field office and maybe that field office is slower, or they need to send an RFE for a medical exam or updated something. But I would suggest 60 days. I mean, obviously with all of these, USCIS is trying to get them done by September 30th, so that's about 60 days from now.
Harsh has this question. Can we do the medical interfile when the case is pending with field office without an RFE? You should. I mean, if I were you, I will. Do the interfile. It may or may not go. When I go to the doctor, I'll get 2 original set of copies. I'll send one. I keep the other one. Just in case I get the RFE, I'll send another one. Rajesh Gurudu from Facebook has this question. Emily, you need to listen to this question. It's very funny that you won't understand it though. You won't understand this, but I will have to. Do you have to take the biometrics? Does the biometrics are void after 15 months after they've been taken though? Of course, the answer is no. Their biometrics are valid. You're good. You don't have to do the biometrics again unless they have some doubt in calling. Now, this is old thing before you started practicing, I believe, that the biometrics used to expire within 18 months or 15 months. And then the problem there was that it takes so much time for us to get the green card. We do the biometrics, it takes 14 months to get the biometrics to there, because right now biometrics take only 1 week or less than 2 days to get it approved. And before we get the green card though, the biometrics expires and they will call us for biometrics again, and the cycle used to go forever. But no, that is not true right now. Biometrics do not expire. You are good, absolutely not a problem. That was an old law, which before Emily came in, that was a law.
Manny says, I filed the standalone 485 application in April. When will I expect my EAD, advanced parole, and GC? Anyone got the approval that filed in April? Could be any time now. It could be you get the direct green card.
April of 2022? Yeah, we got it.
Yeah. So we have received green cards for people that filed in April. We did not get the EAD and AP because they didn't need it at that point. The EAD and AP, I feel like, are taking longer than 4 months. So it's either you'll get the green card, or if your process takes longer, then you might get the EAD, AP if they can't get to the green card in time.
Murli Krishna, please suggest me to whether I should refile or should I wait for the interfile. That's a very tough question, Murli. I mean, there are a lot of things where I would answer the question simply that I would do this, I would do that instead of telling you what to do. But in this case, though, it's a very, very tough choice. It's a coin toss thing. I normally tell that give a coin to a spouse, let her pick the choice, and if she's correct, I should get the credit. And if she is wrong, and we both will curse her. But that's how it is when it's too tight of a call. I let the coin decide it.
Saravanan says, we're hearing that there are no Dropbox appointments available until 2024. Is that true? And we can't travel to India until then. Yeah, I'm hearing that they're not even putting a date. There's just nothing available. You just have to sit and wait and keep checking. And if one pops up, you grab it. I don't know. I haven't heard that there are dates available in 2024. I mean, who can plan out an appointment 2 years from now? That's crazy.
Yeah, H1B might be expiring by that time. The other, Emily, what I'm noticing is that they have to keep on refreshing, and they'll find all of a sudden they pop up there. Or the problem is there are thousands of people. I don't know. I've been heard that there are people who have written programs that refresh, and that's another thing too. But there are some people who are telling me that if you keep on refreshing 3 or 4 times, then it bars you out. So I don't know how that works out.
Interesting.
Does the H1B stamping require J1 waiver approval after 2 years of J1 is complete though? This is for Siesta. If you have been outside the country for more than 2 years and now you're going for stamping, you do not need J1 waiver. And in that 2-year period of time, you have never come back into this country, you're good. The J1 waiver, you don't need a J1 waiver.
Kirti says our case remains pending, saying that there's no visa number available, but it's EB1C. Any suggestions to get this correct? It's current for 2 years now. It could be, so USCIS puts these random case statuses sometimes, and then it stays that way until the next time an officer actually looks at the case and does something. So it doesn't necessarily mean that USCIS thinks that a visa number is not available for you. It's just that they haven't looked at your file to update something which causes the next status to happen. But a lot of times when we're not sure of things like that and want to verify, you can do a Freedom of Information Act request to get a copy and make sure it's showing that it's in the EB1C category, or work with your congressman or senator. They can do an inquiry and verify that for you, but it probably will take maybe 6 weeks these days.
20% of the questions that are come on the prediction of the priority date, what should I do, should I leave the job or not, we will come to know a little bit more clear idea by the end of September 2022. We will get a little bit more clear idea how many, how they will move in October. Somewhere in October, November, we will see how much spillovers are coming from the family immigration into the business immigration. So those are expected that to be seen in September, October, and November of 2022. But it's very hard. The reason is that the amount of green cards, pending green cards by last time we saw was 170,000 green cards pending. In the 485 application, they still had 100,000 to be issued. So there was only 70,000 left. Then we have to see the next year, are they going to plan ahead? Are they going to rush it like the way they did it this year? If they plan to plan ahead, though, they should be moving the priority dates much faster than what they're doing, because most of the people who were before January of 2015 have already filed the 485 application, though. So there's still 140,000 to be given next year, and plus the spillover that is expected to come from the family immigration. And then they need to plan for 2 years. I don't know why they don't plan for 2 years. They only plan for that year. If they're going to give the green card, their processing time is almost 2 years as an average. Why can't they plan it early? Why can't they move the dates right now? Yes, if I were the person who's in charge of the priority date, I would have moved the dates very forward, though. But that's the reason why they wasted the green cards last year. Remember, they knew that the spillover was there. Why couldn't they move the priority date in June, July? Why did they wait until September to move the priority dates? And when they did move, they had no clue should they move EB2 or EB3. They just look into how many I-140s have been approved in EB2 and EB3. That's all. I mean, they should have asked, look, there is something called a downgrade process. They had no clue there is a downgrade process. Neither the State Department nor the USCIS had a clue that people can downgrade and file the 485 application. They should be coming to a Tuesday session from 5 to 6 to educate themselves what is on the other side of the immigration. At least to understand the basic fundamentals of the immigration, the USCIS officials and the State Department officials need to come to our 5 o'clock session to understand, hey, there is a downgrade process. And they moved all the way from everything they moved, EB3 moved forward. They didn't know how to that they downgrade, and then they are moving the EB2 to be forward. I mean, this is ridiculous. So hopefully so they have realized it. Hopefully so they are watching our 5 to 6 thing. Hopefully so they're going to move the dates. But it's very hard, guys. I can't predict. Let's wait for September.
DeBasis says, do we need to submit the I-140 approval notice for the 485 for the derivative applicant? My attorney is saying just submit the A number. You don't need the actual approval notice. I always submit the approval notice. I'm not sure why you wouldn't submit it.
I don't filing standalone application?
Yeah, especially if it's standalone. You might get rejected in the mailroom because they don't see that. And
I will also submit the 485 receipt notice of the husband. I also mentioned that the I-140 belongs to the spouse. She's a derivatory application. I will put a big note in a color paper. Do not reject in the mailroom. Spouses H-1B is pending. I-140 belong to the spouse, so that they don't look into the I-140. Oops, this is not Jane Doe's I-140. I'm going to reject it. They can do that, but I put those things.
Yeah. Yeah, I mean, why would you make USCIS do extra work to look up that other file when we know they can't handle the work they already have that's normal work when we do submit it? So yeah, that seems a little risky to me.
You need to make them easy, their job very easy. As much easy as we can make their job, it'll be so easy for them to take our case and adjudicate our case. If we try to complicate, put a maze in them, yes, they don't have patience for that. There is a certain format they tell us to file the 485 application. It's better to follow that thing. I mean, just follow that thing. You just do a little bit different, they get confused. Oops, what is this? So make it easy for them.
Raju says USCIS issued the 485 Supplement J receipt with an incorrect employer site. Instead of Arlington, it says Newington. The 485J form has the correct details. What should I do now? Don't do anything. These 485Js are not applications. It's just a notice to USCIS letting them know that the job offer is still available. And it does not matter that you even get a receipt. It doesn't matter what's on the receipt. It doesn't matter if you get an approval or not. I would not worry about it.
Ravindra Mishra has a very interesting question. EB2 priority date January 22nd, 2015. Son will age out on 21st July 2023. Should I worry and file his F1? One step that I would recommend probably is it's okay to file F1, but there are other steps that I may want you to do. I want you to withdraw the I-140 of EB2 and file an EB2 I-140 again. And people may think that it is the stupidest idea that you could ever give it to a client to withdraw it and file it because only for you to make the money. Well, of course, I'm not telling that I won't make the money on it if I do it, if I'm your lawyer. Here is the reason why I tell you to refile the application though. Assuming that your EB2 was been approved in premium processing, then it's only 2 weeks. Under the CSPS, Child Service Protective Act though, the amount of time the I-140 is pending will be deducted from the age. If your I-140 for EB2 was been pending for 1 year, it makes sense probably not to withdraw, but it was approved faster, which most probably it is 90% of the time. If you withdraw it and you refile the I-140 again, the USCIS will take 1 year to approve your I-140, most probably. In most of the cases, it's 18 months for you to approve the I-140. Then what happens is that the time period that is there, that means that if your son is becoming 21 for the purpose of filing the 485 application in July of 2023, you can add that 18 months that the I-140 is pending. That's the reason I want you to withdraw and file it again. The second thing is that I may as well file EB2 and EB3 at the same time. Who knows which one will go forward? So if your employer is cooperative, withdraw the I-140, file an I-140 again, file an I-140 in EB3, file an F-12 at the same time. These are the protective steps that you need to take, because you may want to wait for a month to see, but you may want to do it right now. It's up to you. But these are the steps we are telling people that if anybody is coming near the age and the priority date is not current, please do these steps. And maybe you won't understand. You can rewind the tape and look into it, whether or not what I told makes sense under the CSPA Act. There's another video we made on it. It's called CSPA, Child Service Protective Act. It's a 10-minute video that you may want. It may be worth for you to consult a lawyer to go through this process, why Rahul Reddy told to withdraw the I-140 and file it again. Is this guy's only purpose is to make the money, or is there any other reason? You ask a lawyer and they will tell you why I told you this.
Sandy says, could you please provide light on taking a promotion after the I-140 is approved? In this case, after the promotion, the job duties remain the same as what's on the perm, only 5% change. So I think the prevailing thought here is that yes, it's a promotion, but it does not impact the perm. It's not a material change. It's normal career progression. So most attorneys would say that labor certification remains valid, the I-140 remains valid. You can proceed to file the 485 based on it when the date becomes current. There are some attorneys that say, oh, if there's any change at all in what the perm says and what the job you're doing now, we have to file the perm again. And some people will file multiple perms throughout their career because of that. I think USCIS has never come back and said, nope, we're not accepting this 485 because you took a promotion. Never seen that happen. Now, of course, if the location of the job changes outside the area where the perm labor market test was done, that's a huge problem. That's where the perm needs to be redone. But career progression, USCIS understands it. It's normal. And especially in your case, the job duties are practically the same. So I don't see any reason to do anything.
Emily, what if I am working for a consulting company? I'm working in California. And if I move to Texas, do I need to refile the perm application?
In most cases, no, because if you're working for a consulting company on the perm and during the labor market test, they will normally say this job involves work in unanticipated locations. They will run the recruitment, the advertising steps out of the headquarters of the company, regardless of where you happen to be working. And so you can move from place to place to place without impacting your perm when it has that language and they did the labor market test at their headquarters location.
Indranil Mitra has this question. Are you seeing a trends in the 485 application where the primary application is approved a month back and the dependents are pending though? About 5 to 10%, 5 to 8% of the time we are seeing that trend, but it's not like very common. Should I be very worried about it? Is my spouse in danger? I got the green card, she did not get the green card. No, you're fine. I don't see that as a big problem, and there's nothing you can do about it too. But yeah, it's definitely not common, just 5 to 8%.
All right, well, we are out of time for today. Thank you so much for joining us. Don't forget that we have a daily conference call where you can join and ask your questions there. The details for that are at rnlawgroup.com. And of course, please subscribe to our newsletter where we send out the updates of what's going on every week. We'll be sending that tomorrow morning, so stay tuned for that.
Thank you very much.